Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
Welcome to this, our weekly weekend-venued broadcast. My name is Jim Santelle, and yes, I am your host both this hour and next hour as well for Amicus, a law review here on the broadcast stations of Civic Media statewide throughout the state of Wisconsin and certainly beyond as well. Delighted, honored to have you with me this weekend for this, our Amicus presentation, as we do every weekend, focusing upon law, justice, the delivery of justice in America and beyond in many occasions, including today. We take our name, as always, our adopted commission from the notion of reviewing, analyzing, deliberating, considering some of the recent news of our times in those all-important areas of law and government and justice in America in particular. Amicus, as you know, a legal term. It's derived from the Latin. It means to describe a friend, ami, an individual, an organization that assists somehow in some understanding, some appreciation, some assessment of the relevant issues or questions that are before our state, our nation, and in many instances, our world as well. Some issues that need resolution, addressing, and some dispositive treatment, if you will, by a court, a jury, some other entity, even sometimes an individual that is wrestling with some particular issue of challenge and importance for our community. As we do every weekend, we are pursuant to that legal term, and yes, that commission, we are inviting your involvement, your discussion with us on those issues that we are going to be taking up this weekend. You do that by one of two ways, but you can call in and speak to Max or me. Max, my wonderful producer here in the studios of Civic Media. You can call in at 844-967-2789. That phone number, once again, is 844-967-2789. Or we'll also take a note from you. You can drop something, and Max and I will take a look at it in the Civic Media app, engage in our conversation on the syllabus topics of this weekend. Today, as in the past, focusing a lot upon justice and courts in particular. In our first hour, we're going to be doing something of a transition from our previous broadcasts of previous weekends, focusing specially upon the United States Supreme Court, talking as we have in past weeks about those 60 or so cases, now a part of history in America, including some major decisions having to do with the immunities attended upon a president of the United States of America, and also the ways in which our government works under this newly revised process established by the Supreme Court, getting rid of Chevron deference, a new relationship between agencies and courts, in one of those cases establishing a huge amount, I would argue even an unconstitutional amount of power vested in the executive branch, and in the other case, a huge amount, arguably inordinate to the Constitution as well, a great deal of power vested in the judiciary. Both of those cases join about 50 or so other matters that we've likewise described here on our broadcast station. Although we are in this period transitioning to our regular rule of law analysis, many things going on just this past week in our state, in America, and throughout the world, we necessarily have, as I indicated, a transition from those focuses upon the Supreme Court cases to a specific thing that happened in one of those cases and having to do with the prosecution of a former president, his name is Donald Trump, in the Southern District of Florida. So we're going to begin our syllabus, our amicus analysis this weekend by focusing upon this major decision, one of the big news stories of this past week in the area of rule of law, in which Judge Aileen Cannon, she's a federal district court judge. She is in the Southern District of Florida. That's where this documents case alleging that Donald Trump, just as he was leaving and since the time of his departure from the White House, took with him, retained used various documents, also engaged in conspiracy to avoid and obstruct justice in an attempt to identify those documents and to get them back into the right hands. All those allegations in a complaint, in an indictment that has for about a year been pending in front of Aileen Cannon in that Southern District of Florida jurisdiction. Just this past week, major news story, Aileen Cannon dismisses the case outright, makes it very clear this case is done. She does so on the basis that the special counsel, Jack Smith, does not have the authority to prosecute this case. We're going to unpack that notion that does indeed come from one of the concurrences in the Supreme Court decision of a couple of weeks ago, finding that the president is immune, either completely immune or presumptively immune from prosecution under our federal criminal code. We're going to talk about the genesis, the basis for Judge Aileen Cannon's dismissal, and what this means for the future. What are the options that are now before the special counsel? What has he done already in the wake of that dismissal? What does it mean for the future of that case? We're going to chat about all of that, going to dive deep into the bases for her decision and also the ways in which it runs afoul of virtually decades of decisions in this area that support exactly this kind of prosecution. We're going to talk all about that, invoking not only recent case law, but also the traditions of our United States Supreme Court. Then, in a continuing focus on the Supreme Court, we're going to be talking about another major news story of just this past week, indicating that along the way, the President of the United States of America has had his attention focused upon the Supreme Court. And just this past week, the president indicated that he has got some plans. He has got a package of proposals, some of them legislative, some of those related to changes, proposed changes in the Constitution of the United States of America to address some of the challenges, problems, issues that he and many of the rest of us in America have identified when it comes to the administration of justice in and through our United States Supreme Court. We're going to talk about what Joe Biden may in fact be announcing in the relatively near future, what he hinted at this past week. What are the dimensions of that? What does it mean? And what does it say? What does it not say about what the president is planning to do, at least propose to do, when it comes to the engagement of the people of the United States of America with our United States Supreme Court? And finally, as promised last week, we give you a little bit of a sampling of what the Supreme Court has already done in terms of identifying cases. Yes, that's right. It's not too soon to begin to talk about the next term of the United States Supreme Court. That begins, of course, in early October of this year. Not that far off. The Supreme Court has already identified something in excess of 20 cases already on its docket for this coming term. Cases it will be entertaining through oral arguments, as we've talked before, memorandums, briefs filed by the parties, and ultimately, at or about this time again next year, the United States Supreme Court issuing decisions on that next batch of cases, that next set of cases now being a part of its docket. Again, before the United States Supreme Court, we'll give you some sense about 6 new cases added to that list as a part of the Supreme Court's review coming up in the coming year or so. Of course, we'll continue to monitor and report and analyze the oral arguments on those cases as well. All of that coming up in our first hour here on Amicus, a law review. We've got a important second hour as well. It includes a lot of foreign aspects, a lot of overseas things. Yes, rule of law does not stop at our border. And we know that there are an awful lot of things going on in our federal and state courts that have implications overseas, and likewise, a lot of things going on overseas that have implications for our nation and our state. We're going to talk about some of those countries, and they include Egypt and South Korea and Israel and Russia. And I suspect you probably know what the news stories are that generate our focus on those 4 different nations. We've got the recent conviction of sitting Senator Robert Menendez for violations of the federal criminal code when it comes to corruption and other events. We're going to talk about that particular prosecution and what we can take away from not only the substance of what he was convicted of, but his reaction to that conviction, offering to you today that it is an example of how defendants can and should respond to the processes of our criminal justice system, as opposed to the ways in which our former president has responded in attacking the very notions about how we do criminal justice. We're going to talk about the Menendez conviction and the judgment there coming up. We're going to talk also about the decision by the United States Department of Justice to charge a former CIA analyst with crimes, again, against the federal criminal code, coming in connection with her association, longstanding, both academic and official, but with South Korea. We're going to talk all about that, what that means in terms of what the Department of Justice is doing there. We are necessarily going to talk as well about a major decision issued by the International Court just this past week. The International Court making some determinations, some findings about the occupation and the settlements in the West Bank in Israel. What does that mean? What did the International Court say this past week about the West Bank settlements and the West Bank possession of that territory by the state of Israel? We'll talk about the reaction by the Prime Minister Benjamin Netanyahu in that nation. And we'll talk about the rule of law implications for that as well. And finally, in comparison to much, some, all of that, we're going to focus upon this major prosecution and the sentence imposed upon this Wall Street Journal reporter who's been in the custody, the control of the Russian government. He was sentenced just this past week by a Russian judge to 16 years in a penal colony in Russia. We're going to talk about what that means. We're going to talk about the distinctions between the way the Russians do things and the way we do things. We're going to talk about due process, substantive and procedural, and the ways in which we can, in the midst of the imperfect nature of much of what we do in America, nonetheless, the brightest, wonderful, most wonderful country on the face of the planet that does indeed aspire, and in many ways, on a daily basis, in fact, achieves justice in the courts of America. We're going to contrast that, do some comparative justice when it comes to the ways in which this particular defendant has been treated in the Russian courts. All of that coming up on this hour and next hour here on Amicus, a Law Review. This is Amicus, a Law Review. My name is Jim Santelle. I'm your host this hour and next hour here on the broadcast stations of Civic Media. Delighted and honored to have you with me on our weekend broadcast in our discussions of the intersection between the news, both national and international, and the rule of law, the delivery of justice, and in many ways government in our nation and beyond. This major news story coming out early this past week that the federal district court judge, her name is Aileen Cannon, who's presiding over this major prosecution brought by the U.S. Department of Justice through the Office of the Special Counsel involving the documents. These are the so-called Mar-a-Lago classified and sensitive documents. That's the predicate for the case brought against him, alleging both Donald Trump and two others also engaging in obstruction of justice in attempts to try to prevent the discovery of relevant information, to hide what they were doing when it comes to maintaining those records, keeping those records, storing those records, certainly at the Mar-a-Lago residence. We have seen the photographs of that and other evidence coming out of that case, also at Bedminster in New Jersey, and plainly documents taken from the White House in the final days and hours, perhaps, of the Donald Trump presidency. The federal judge, Aileen Cannon, just this past week, serving up a major rule of law decision in that case and finding that it has to be dismissed, gotten rid of. And in her docket entry at the end of her 93-page order, she makes very clear that she is done with this case. There is nothing more to deal with. She not only dismisses the case without prejudice. We're going to get back to that in just a moment or so. That's a significant aspect of this, but says that she is done with the case. No more hearings, no more pleadings, no more motions, no more hearings of any kind to try to address all the kinds of things that are still pending on that docket before the dismissal. She has directed the clerk of court to close out the case, and it is done. And again, the predicate for her doing that is not in the substance of it. She's not making findings about whether or not there was a substantive determination of whether Donald Trump did, in fact, do the things alleged in the multi-count indictment against him. That, of course, ultimately for the determination of a jury. She doesn't do that. She presides over the case, ultimately for a jury to decide, a jury that, at least for now, she has indicated she is not going to preside over. She has done this instead on the basis that the prosecutor himself, Jack Smith, the special counsel, appointed by the Attorney General, was not properly appointed by the Attorney General without authority, either statutory, something passed by the Congress, or in the Constitution. No basis for doing that under either of those doctrines, either of those theories, and therefore, absent authority of the prosecution, in the prosecution to do this, the entire case has to go away. Now, plainly, a major victory in the litigation for Donald Trump and for his defense counsel. They have raised this issue there, and as we have talked in other settings as well, the implications of this go far beyond just the Mar-a-Lago case, about which we will talk here on Amicus Law Review. Let's talk, however, about where this comes from and what the tendril is. What is the connection between what Aileen Cannon did this past week, removing from her docket this major Mar-a-Lago documents case, and the United States Supreme Court? Well, it goes back to something that we have spent a lot of time talking about on this broadcast here on the broadcast stations of Civic Media. You recall well that on July 1 of this year, the United States Supreme Court issued this major opinion. We've analyzed it in detail, provided you with a lot of information about what it says, what it doesn't say. We've talked about the dissenters who are aghast at what the Supreme Court has done. And what the Supreme Court has done is establish that for some things, there are absolute, complete immunities that are vested in the executive branch, in the president. Can't touch him, cannot prosecute the defendant, an executive defendant, for crimes committed in office, and for many other things, presumptions of immunity. And those relate to other things within the outer perimeter, as the Supreme Court says, of official duties. All of that we have talked about before. Along the way, in addition to that majority opinion that is joined in by 6 members of our Supreme Court, authored by the Chief Justice himself, his name is John Roberts. In addition to that, we made passing reference in the past to the 9-page concurrence, the additional piece that was added on, if you will, by another justice of the Supreme Court who agrees with the overall opinion of the majority, but nonetheless says, I would have come to that result in an easier, more direct way. And specifically, this is Clarence Thomas, who says at the outset and throughout his 9-page concurrence, it is not the law of the case, but nonetheless, his observation about how this could have been taken care of. He says it's difficult to see how the special counsel has an office established by law as required by the Constitution. Now, he's talking about the special counsel, Jack Smith, the same attorney who's prosecuting the Mar-a-Lago case, but he's talking about the prosecution against Donald Trump for election interference in the District of Columbia. Even so, he's talking about the same concept, the same person, the same entity, the same office that is prosecuting the Mar-a-Lago case. And in particular, let's review a bit of what Clarence Thomas said in his 9-page concurrence. He said the Constitution sets forth how an office may be created and how it may be filed. And it is important, he says, and it's important for all of us to focus on what is going on in South Florida, what's going on in this concurrence, by understanding, as Justice Thomas cites in his concurrence, the exact language of the Appointments Clause. It says this: the president shall nominate, and by and with the advice and consent of the Senate, we hear that term a lot, that phrase a lot, shall appoint ambassadors and public ministers and consuls and judges of the Supreme Court and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. That's the Appointments Clause of the U.S. Constitution. It is found in the second portion of Article 2 of the Constitution of the United States of America. Now, what is it that Justice Thomas finds so objectionable here? Well, he says, again, impossible to identify exactly how a special counsel has an office established by law as required by the Constitution. Goes on to say, when the Attorney General appointed the special counsel, he did not identify any statute that clearly creates such an office. So initially, again, the Associate Justice indicating there's no statutory authority to do this. Goes on to say this, nor did he rely on a statute granting him the authority to appoint officers as he deems fit, as the heads of some other agencies have. Instead, he says the Attorney General relied upon several statutes of a very general nature. Says none of those statutes cited by the Attorney General appears to create an office of the special counsel, and especially not with the clarity typical of past statutes used for that purpose. In the end, the Associate Justice, Clarence Thomas, says, because of the constitutional infirmity, because there's no statutory basis for any of that, what has to happen here is that the lower courts need to take a look at all of this in determining whether or not there's a basis for the special counsel to do what indeed he's doing in that case. Why is that relevant? As we come back, we're going to talk about what Aileen Cannon did in picking up on that language and choosing to dismiss the case coming out of the Southern District of Florida. This is Amicus Law Review. My name is Jim Santelle. We are talking in this, our first hour of our weekend broadcast, all about the transition between this concurrence written by Clarence Thomas and the decision of just this past week issued by Federal District Court Judge Aileen Cannon dismissing the so-called Mar-a-Lago documents case. Near the conclusion of his opinion in that concurrence in the Trump versus United States case, Clarence Thomas says, these are serious questions I'm raising about the statutory and constitutional authority of the special counsel to prosecute this case. He says those questions must be answered before the prosecution can proceed, and then invites this. He says the lower courts should answer these essential questions. Indeed, that's exactly what Aileen Cannon picks up. And that's exactly what, at least from her perspective, she does. Again, in this major decision, 93 pages, she says that there's no federal statute, there's no constitutional basis for the special counsel's prosecution of the case, mirroring almost completely exactly what Clarence Thomas has said in his concurring opinion. He did it in 9 pages. She did it in 93. Interestingly, somewhat lost in some of the media coverage on this, she also finds that Jack Smith had been improperly funded by the Treasury Department, and therefore there was an appropriations clause problem with this as well. So we've got 2 issues, principally the appointments clause, but also the appropriations clause. And of course, all of this comes in the midst of what was once identified as one of the most straightforward of the 4 criminal prosecutions against Donald Trump as they've been brought by both federal and state officials. He is charged once again in this case with illegally holding on to these classified national security materials after leaving office. That a source of no small concern, a national security concern about who else has seen these documents, who else had access to them at Mar-a-Lago, maybe in New Jersey as well, other places, raising issues not just about the paper movement, but about threats to our national security. And that's why this case has been and remains so very important. And along the way, after the initial indictment was returned by the grand jury, finding probable cause to believe that indeed those crimes had been committed, grand jury returns and says, we're going to add some obstruction of justice charges to this as well, in the efforts to retrieve some of the information there, obstruction of justice alleged against Donald Trump and against two co-defendants, two of his workers there. Remember their names, Walt Nauta and Carlos de Oliveira. Both of them, also defendants in this case, also dismissed by virtue of Aileen Cannon's omnibus dismissal order of just this past week. Special counsel Jack Smith, of course, responds, and he says this. He says the dismissal of his case deviates from the uniform conclusion of all previous courts to have considered the issue that the Attorney General is statutorily authorized to appoint a special counsel, and the Justice Department has authorized the special counsel to appeal that court's order. Indeed, that's exactly what Jack Smith has done following the issuance of this order, bringing to an end, at least for now, the progress of this case in front of Judge Aileen Cannon. He has appealed this decision to the 11th Circuit Court of Appeals. That is the Court of Appeals directly above the district courts in the 11th Circuit, including South Florida. This is the same court that on at least two occasions in the past has rejected positions articulated by Aileen Cannon when it came to that civil attack on the conduct of the criminal investigation that preceded all of this. Now, all of that's very wonky. All of that's a lot to consume. But the bottom line is the 11th Circuit has already on two previous occasions told Aileen Cannon that she is wrong and reversed her and told her she's got to reinstitute not only the proper adjudication of justice, which in that previous case meant hands off when it comes to attempting to oversee the investigation. Now she's shut down the actual prosecution. We'll see what the 11th Circuit does. Highly likely, the 11th Circuit will follow what the Supreme Court has said and what all these other courts have previously said in deciding that special counsels and special prosecutors are in fact constitutional. In that 93-page order that is now on appeal to the 11th Circuit, by far the longest writing that she has issued since she has been handling this documents case for about a year or so, she offers what is admittedly an in-depth look at her legal reasons for tossing out the charges. At the heart of her thinking, again, was this assertion articulated by Clarence Thomas, articulated at much greater length by her in her exposition, that there's no specific federal statute that authorized the appointment of special counsels or gives them the prosecutorial power that they have wielded for almost a quarter century. Nothing constitutional either. Now, just as a way of some background here, special counsels are currently governed by Justice Department regulations that for a long period of time have been supported by federal laws that lay out the structure of the department and the specific powers of the Attorney General. All of that has been established at least since 1999, when the Congress, the statutory authority here coming from Congress, establishes something called the Independent Counsel Act. And that at the time governed a different type of independent prosecutor, and that was at the time of the so-called Whitewater investigation into Bill Clinton's matters, not only with respect to Whitewater, but also ultimately Monica Lewinsky. Judge Cannon basically took a wrecking ball, if you will, to all of that, and so that none of that is supported by the Constitution or by the statutory authority here. She declared that allowing special counsels to operate under the control of the Attorney General was a violation of separation of powers, and she invites, in this way, language I will read from the order, invites Congress to pass a new law if indeed you think that Mr. Smith should continue to pursue this and other cases against Donald Trump. She says this: if the political branches wish to grant the Attorney General power to appoint Special Counsel Smith to investigate and prosecute this action with the full powers of a United States attorney, there's a valid means by which to do so. Now, all of that sounds good perhaps on the surface, but for the fact that it is simply wrong. And not only is there statutory authority, but it has been affirmed by the Supreme Court repeatedly in recent years. In addition to this appropriations, this funding issue, also a matter of review by previous courts. The judge in this case appears to agree with this argument that drawing funds from the Treasury without statutory authorization, good reason to believe that the Appropriations Clause violation here also happened. That's a separate independent basis. And of course, all of that comes together at a time when, as a result of this, the case now dismissed in front of her. Now, Justice Thomas never mentioned Judge Cannon in his concurrence, but he did recommend, once again, the lower courts take a look at that, and that is exactly what Judge Cannon has now done. The reality is that there's a great deal of history on this, as I've indicated, supported by the Supreme Court and other lower courts that have affirmed the capacity of the Attorney General to do just this. They've included the Supreme Court way back in a case called the United States versus Nixon, 1974. Supreme Court upholding the appointment of a fellow named Leon Jaworski. Many of you may remember him. He was investigating Watergate, the obstruction of justice events at those times. And interestingly, United States versus Nixon, 1974, a unanimous court, 9-0, written by the Chief Justice. His name is Warren Burger. Warren Burger, writing for a unanimous court, says two things. One is, he says there's no such thing as executive immunity. That doesn't exist. That doesn't exist. United States versus Nixon, 1974. And he also goes on to say that while we focus principally on this notion, dismissed, that there is executive privilege, there's executive immunity, the reality is that there is, in fact, constitutional capacity for the special prosecutor at that time, again, Leon Jaworski, to investigate, finding expressly in United States versus Nixon precedent for decades that this kind of thing can, in fact, be done. And it goes on. During the course of the subsequent years, we know well that that same notion, gotten different names, special prosecutors, special counsel. It has changed over time as the Congress has tried to wrestle with this issue of authority and how exactly a special counsel, a special prosecutor is to operate inside the Department of Justice, and yet with sufficient integrity and apartness from the Attorney General to ensure the American public has confidence in that process. As the courts have gone along, they've reaffirmed this basic notion that you can, in fact, have special prosecutors and special counsel. They did it in the investigations involving President Ronald Reagan. Remember the Iran-Contra scandal? Same thing affirmed there. President Bill Clinton, as I just said, in the Whitewater Monica Lewinsky scandal. Same kind of thing. President Donald Trump in the Russia 2020 campaign interference investigation, all of those special counsel, special prosecutors, all of them affirmed by the courts, overruling and finding expressly, as did the Supreme Court, that Congress has indeed, contrary to what Aileen Cannon says, and yes, what Justice Clarence Thomas says, Congress has vested in the Attorney General both the power to conduct criminal litigation of the United States, and here we go, to appoint subordinate officers to assist in the discharge of those duties. The statutory authority is there. The constitutional authority is there. The Supreme Court has said so. Other courts have addressed this, and indeed, those same principles also animate recent investigations. We know them well. Right now, the investigations of Hunter Biden, who was recently convicted in that firearms case in Delaware. He is going to be sentenced sometime soon. He's also awaiting trial in a tax matter out in California. Those cases also being prosecuted, again, inside the Department of Justice, but by special counsel. In that case, a fellow named David Weiss. Those prosecutions also supported by all of this precedent, and indeed also precedent for the investigation of President Joe Biden. He was investigated, remember this, for possessing government documents, a finding by Robert Hur, the special counsel in that case, also justified in that investigation judicially, and finding in the end that there's no basis upon which to pursue an investigation of the president for that, finding in the end that there would not be charges against him. All of those recent cases being brought by, being investigated by, being pursued by special counsels pursuant to the clear statements by the Supreme Court that this is permissible, contrary to the express opinions issued by Aileen Cannon and by Clarence Thomas. And so what happens in the wake of the clarity of all of this
and the wrongness of the decision issued by Aileen Cannon, seizing on this one issue and getting rid of everything else. Well, we know what's happened once again. We know that Jack Smith has already appealed this decision to the 11th Circuit Court of Appeals, bringing this up and certainly going to be arguing in the months ahead based upon briefs and oral arguments to the 11th Circuit, a 3-judge panel there asking once again that the 11th Circuit reverse Judge Cannon as they have done on 2 previous instances, telling Judge Cannon once again that she is wrong and asking that this case be reinstated based upon the fact that her bases for dismissing the case are not well-founded, are not consistent with precedent, and are inconsistent with the law as established by the Supreme Tribunal in our country, the United States Supreme Court. He has done that. And sometime in the next several months, the appeals court presumably will entertain those arguments, both written and oral, and decide on that issue, almost certainly going to say that indeed Aileen Cannon is wrong, and implicitly, that Clarence Thomas is also wrong. Note in his concurrence, nobody else on the Supreme Court joins him in that view. Nobody else agrees with Clarence Thomas on this issue, likely to assume that nobody else agrees with Aileen Cannon on this either. Now, there are a couple of other remedies that Jack Smith could consider, and he certainly has, no doubt, inside the Department of Justice, thinking about what do you do in the wake of the dismissal of this very important national security case. How do you remedy this matter brought on by a judge who is engaging in what many have called a lawless decision? 2 of the things that he plainly can do. One of them, of course, he could ask the 11th Circuit to seek her recusal, ask them to remove her from the future pendency of this case. Let us assume that at some point down the road, the Supreme Court does indeed reinstate this. He could also ask that she be taken off the case. He hasn't done that up to now. That's an option. As Amicus Law Review continues, I'm going to tell you about another options out there for the special counsel as he addresses this decision by the district court in South Florida.
Amicus Law Review. My name is Jim Santelle, your host this hour, and also next hour when we talk about the Supreme Court and lower courts in our nation, talking right now about this major decision by Aileen Cannon to dismiss the documents case, one of those 4 criminal prosecutions proceeding against Donald Trump, who is now the nominee of the Republican Party to become the president of the United States of America. Another option that is out there for Jack Smith that all the prosecutors certainly identified, he is apparently not going to pursue this. It's not clear whether he's going to ask the 11th Circuit to recuse Judge Cannon, assuming that it sends this case back to the district court, reinstates it. Not clear that he's going to ask that she be taken off this case, although that is certainly an option that is before him. Maybe the 11th Circuit would be interested in at least considering that. Hasn't done so yet, at least not publicly in pleadings. But there's another option that apparently he is not going to pursue, and that is simply to re-indict. That is simply to go back to a grand jury, a new grand jury, as they did in this case, and present the evidence again to that grand jury. No problem here. No problem at all with double jeopardy. Jeopardy is not attached. Nothing about this violates the Constitution. To go back to a grand jury and say, we're presenting this evidence anew. We're asking you to determine whether there's probable cause, and do all of that, not through a special counsel, but have the Attorney General or someone in the criminal division address the very issue that Aileen Cannon has apparently identified as being problematic. If you don't like the special counsel, Judge Cannon, we'll do it another way. We'll do it the way that 99% of all the cases in America are prosecuted. What we're going to do is we are going to assign this to someone, a trial attorney in the Department of Justice, no special counsel, no special title, no special prosecutor, an assistant U.S. attorney in the Southern District of Florida, in the District of Columbia, maybe in New Jersey, a trial attorney in the criminal division, the public integrity section of Maine Justice, a mainline prosecutor, a civil servant there for a long time with this experience, no special counsel appellation, no special counsel designation. We'll do this as we normally do. Have that attorney prosecute the case. We get out from under this problem that you've identified, Aileen Cannon, inappropriately, wrongly, as being problematic, but we can pursue it in that way and get this done as well, alleging virtually the same crimes as before and reinstituting this case, addressing, if you will, the problem the judiciary has identified, at least these two, a justice and a district court judge, and getting this case back on track. And the advocacy to do that, of course, would be nothing wrong with doing that constitutionally or statutorily, but it's a strategic decision that Jack Smith can, in fact, make if he wants to do that. He has chosen to go down the appellate road almost certainly longer in duration. Unlikely, almost impossible to believe that under either path, this case will go to trial. The appellate route going to require, again, oral arguments and motions and memorandums, a decision probably in 2025. You go the other route, a reindictment of the charges, as a grand jury may, in its discretion, determine to do. That process can go forward in the next weeks and months and return to the docket, whether it is in South Florida, in the District of Columbia, all places where there is what's called venue, the possibility of bringing this case. The best one is probably South Florida, where most of the documents were found, discovered, retained. But we also have a tendril there in Washington, D.C., where the documents were taken out of the White House. There's certainly an indication there's something going on in New Jersey. Some of the documents were there as well. You've got venue in a number of different spots. You could consider that. But you can also consider doing this again, assigning it to an assistant U.S. attorney in South Florida and saying, prosecute this case. And go ahead and restart this process, get the arraignment underway, get the motion practice underway. Whether it's assigned to Aileen Cannon or another judge, that is a matter of, again, of course, for judicial administration. That is another remedy that is out there. We will see how all this plays out, continue to report on it, and describe further what happens in the wake of this momentous decision, a decision by Aileen Cannon that virtually everybody on all sides of the political aisle and all sides of the legal aisle, if you will, all ideologies look at this and say, this cannot and will not stand. We will see what the 11th Circuit does. Unlikely the Supreme Court is going to embrace this notion either. We do know that in the wake of all of this, that this has caught the attention of the President of the United States of America as well. And in particular, although he has not announced it with great clarity, President Joe Biden has indicated that he is going to make some proposals, both statutory and legislative, to address what he has identified as a number of different concerns and challenges, out-and-out problems that many of us, including the president, and people, again, on all sides of political aisles have identified with respect to the management, the administration of justice, and even the behavior of the justices on the Supreme Court. The president said just this past week that he has been working with constitutional scholars for the last 3 months on a package of reforms that will affect the work, the conduct of the Supreme Court. And he said, I need some help. He said, I'm going to need your help. And he's talking to the American public, your help on the Supreme Court, because he said, I'm about to come out with some proposals that have been under consideration. He says, I don't want to prematurely announce it, but I'm about to come out with a major initiative on limiting the court and what we do. A major initiative limiting the court on what we can do. Presumably based upon all the indications, he may in fact be calling for a constitutional amendment that could limit this broad presidential immunity that the court's conservative majority has just issued as of July 1. That's a big lift. That is a big lift. And that may be a part of his package, and it may in fact be a part of what he's going to propose. Of course, the president has also described this immunity package, the immunity issue rather, the decision, as being a dangerous precedent, and that there are virtually no limits on what a president can do. An amendment, however, to the Constitution, as we all know well, would presumably face even greater challenges. It would require 2/3 votes in Congress and presumably ratification by 3/4 of the state legislatures as well. That's no small thing, but it underscores the focus that the president has in rejecting the powers that have been given to him by the Supreme Court, establishing a kingdom, if you will, in the presidency, as many have said. He's rejecting that and also saying we need a constitutional amendment to overcome
what the Supreme Court did in this recent case, United States versus Trump. In our next hour, I'm going to tell you more about this package of things the current president is proposing, including likely issues related to term limits and also an enforceable code of ethics. Term limits, and also a code of ethics on the justices. All of that coming up in our second hour here on the broadcast stations of Civic Media on Amicus, a law review.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Jim Santelle, and yes, this is Amicus, a law review. This our second hour of our weekly weekend broadcast about all things justice-related, government-related, rule of law-related, spending much of our first hour chatting about this major decision coming out of South Florida by Aileen Cannon, dismissing the Mar-a-Lago documents case, getting rid of the prosecution against three of the defendants, including Donald Trump and two others there, and raising again in the national attention this issue of whether or not Jack Smith is properly constituted under the Constitution and statutes of our nation, a position that has been affirmed repeatedly by the Supreme Court and by other district courts over the period of decades, establishing clearly that Aileen Cannon, although she tries to distinguish her situation from those other cases, dismissing much of what those other courts have said as dicta, meaning not really the compelling substance of those cases. Nonetheless, a decision that flies in the face of all of those other opinions and getting rid of the case in front of her. Significantly, of course, this decision finding that Jack Smith out of the district court there in South Florida does not have the authority. Also seeing some tendrils, some waves coming out of that in other areas. Certainly going to be raised again in front of Tanya Chutkan. We know as well that she has got the responsibility to handle now this election interference case. It's been pending in front of her for a long time, suspended by the Supreme Court, addresses other issues, including immunity and statutory basis for proceeding. She will also now have in front of her another renewed motion by defense counsel, asking that Jack Smith be thrown off the case there as well. She will certainly deny that motion. I suspect fully that she will embrace all of the tradition that has been happening out there for years and deny that request. But note also that the president's own son, Hunter Biden, in his cases that are pending, also brought by special counsels, his name is David Weiss, he has now renewed his claim in those two courts that those cases be dismissed against him on the same basis, pointing to Aileen Cannon's decision and saying, gee, if it works in South Florida, why should it not work in Delaware and in California? Unlikely the district court judges in those cases will embrace what Aileen Cannon has said and say, yes, indeed, you're right, Hunter Biden, we've got to get rid of these cases as well. But it does have those tendrils and is being advanced by defense counsel to stop the further prosecution of those cases as well, always affirming the capacity, the obligation of defense counsel in our system, the important role that they play to advance those arguments, even if in the end they're unsuccessful. That's what our process is all about. Simply noting that the identification of this issue as being significant and material by Aileen Cannon when it is not is also giving rise to more litigation in these other areas. Also giving rise to some of the president's recent concerns about the Supreme Court, where at least this idea of special counsel authority had some beginnings with the concurrence of Associate Justice Clarence Thomas. Right before the change of the hour here on Amicus, a law review, talking about President Biden's indication that sometime soon he is going to be presenting a package of things to be considered by the American people, by the Congress, in addressing challenges presented by the actions, both judicial and non-judicial, of the Supreme Court,
proposing presumably a constitutional amendment that would rescind, overtake this recent decision of the Supreme Court that finds that a president has immunity. The current president, Joe Biden, expressing outrage that that would be the case, instead embracing 248 years of history and saying we've got to get this clarified and we've got to get the decision by the Supreme Court, the 6 members of our Supreme Court who think that the president is in fact a king. We've got to get that restated in the Constitution. We didn't have to do that, presumably. It's implicit, if not explicit, in the very way the Constitution is set up. But if we need to do it, the president says, let's do it. And he is presumably going to propose a constitutional amendment, a heavy lift because of the mechanism by which that would be accomplished. Other things, however, that he's also presumably going to propose may require also a lot of activity, a lot of engagement, a lot of agreement, which probably doesn't exist inside the Congress right now, but not the heavy lift of a constitutional amendment. Also suggesting term limits. Term limits. Now, we've talked a lot in this broadcast and in other broadcasts of civic media about this notion that under the Constitution, our federal judges, district judges, federal judges at the appellate level, and the justices of the Supreme Court have had lifetime terms in office, lifetime tenure based upon this language in the Supreme Court that says that they will serve there as long as they're engaged in good behavior. That's the way James Madison wrote it. That has been interpreted for a long period of time as meaning lifetime tenure to this day. And some of the legislative proposals do not rescind that notion, but say, you know what, let's create term limits even inside that concept. A senator named Sheldon Whitehouse, Dick Durbin, also from Illinois, have advocated for some legislation that would say we're not going to strip you of your position as a Supreme Court justice. You will still stay there for life. We're simply going to redefine the time period in which you're going to be serving on the 9 members court itself, making decisions on behalf of the nation. We may assign you to some other duties and tasks as a continuing Supreme Court member, but others are going to take your position after, say, 10 years or 15 years, whatever the term limit might be in that legislation. It is a very interesting concept. It may or may not run afoul of the Constitution, but it's a proposal, obviously, that is being articulated seriously by members of Congress and also presumably now by the President of the United States of America to address some of the concerns that he has seen in the United States Supreme Court, the possibility of legislatively establishing term limits inside the constitutional parameters of the Supreme Court's authority. And there's a second one that's also accessible by legislation. And that is the establishment and enforcement of a code of ethics. We have talked about that so much on this broadcast. The need for a uniform, enforceable code of ethics that applies not only for recusals of justices when they have personal and professional conflicts of interest, which have identified, when they have engagements with individuals who appear in front of them, other sorts of things, subject matter that their spouses may be involved in, all of those kinds of things, and then more generally, the sources of their income, gifts given to them, vehicles, trips, all those kinds of things, reporting obligations, a uniform code of ethics that does indeed apply to lower court judges in the federal system, district court judges like Aileen Cannon, federal appellate court judges like those in the 7th Circuit, in our circuit here in Wisconsin and Indiana and Illinois. Proposal also for the establishment of a legislative code of ethics. Now, we know that at least one justice of the Supreme Court, Sam Alito, has expressly said, you can't do that. Stay away. There's no authority in the Constitution to do that. The Chief Justice has declined efforts by the Senate to call him to a committee meeting and talk about this possibility. And he himself, while he's assembled kind of an amalgam of standards for behavior by the Supreme Court, he has expressly rejected this notion of a legislative imposition of a code of ethics. The president now appears to be suggesting in his forthcoming package that he would recommend that Congress go down that road. If they do it, the legislation happens. Again, a big lift given the present composition of Congress, but nonetheless that he would sign it. The president, however, also indicating it's unlikely to embrace what's the most radical idea right now being pushed by some of the activists out there, and that is packing the court, increasing the number of justices, which has been done and can also be done legislatively. Our court has been as low as 5, proposals to increase it as much as 11. You can set the numbers of justices on the Supreme Court based upon, again, legislative decision-making. Both houses of Congress pass legislation establishing the number at a certain numeric level and having that legislation passed by the Congress, and then presumably a president enabled to nominate, with the advice and consent of the Senate, people to fill those positions. President apparently not going to go down that road. He said if we start the process of trying to expand the court, we're going to politicize it, maybe forever, in a way that is not healthy. And he said that in an interview with MSNBC not too long ago, presumably not a part of his proposal. And yet, among the things that legislatively could be done, certainly proposals in Congress to do all of that. Major things underway right now when it comes to the Supreme Court and other things related to the interaction between the people of the United States of America, the decisions being made by the Supreme Court, the actions of the Supreme Court members themselves, and the ways in which we understand the rule of law in America. We always appreciate your comments and your questions. We've got Mark from Prairie du Sac, who's been on the line for a while. Mark, glad to have you with me for your question or inquiry about our subject this morning.
Yeah, thanks so much. And the whole good behavior thing is mentioned, and part of and the whole presidential immunity thing, and for the justices thing was actually discussed in the Federalist Papers. And 75 right? For the president, where it was talking about an avaricious or ambitious man being chief magistrate, as they described it. But further to go on with in Federalist 81. Hamilton actually talks about, that the Supreme Court, might get to a point where they make decisions that are uncontrollable and remediless. That because if the Supreme Court is assumed to have that much power, I mean, that was one of the concerns that the people had. Hamilton was addressing their concerns about in the upcoming Constitution, in response to the Anti-Federalists, who were afraid that we would have courts like we had in the days of the monarchy, where the courts were bribable, they were corrupt, where the monarch could just say, "You do this for me, and this is what I want to see a decision reached," and that flies in the face of even in antiquity for judges to accept bribes, because in ancient Persia, corrupt judges were taking bribes were executed by the king. I mean that it is just. Where bribery is actually mentioned in the Constitution as something that could get you impeached, removed from office.
Right.
This current Supreme Court has decided, well, those aren't bribes; they're just gratuities. Well, I say BS to that, because and ironically, with the new Supreme Court decision saying that federal agencies don't have the power to regulate, certain conduct at all. Why does the FCC have the authority to regulate the content? What I can say on the air right here, where I can't use George Carlin's whole panoply,
all kinds of things, Mark, out there, right? Recent decisions, you make reference to this opinion that we've discussed also coming out of the Seventh Circuit, describing the difference between a gratuity and bribery. All those kinds of things, presumably in the focus of the present president as he thinks about remedies, as you think about them, as we all consider the United States Supreme Court. I'm going to talk a little bit more about other cases coming up before the court when Amicus, a law review, continues here in the broadcast stations of Civic Media. This is Amicus, a law review. My name's Jim Santelle. Taking calls here at 844-967-2789. Max and I also accepting your inquiries by dropping a line. Drop us a note in the Civic Media app. Let us know your question, your inquiry about what we're talking about here this morning. Mark, right before our previous discussion here, also expressing great concerns about the Supreme Court. Its efforts not only to identify what the law is and is not in America, but also doing things in ways that raise issues about its integrity and other concerns that, Mark, many other Americans raise these days. We know that all of this is happening, including the president's forthcoming proposals to, as he says, do something with respect to the Supreme Court. All this happens as the Supreme Court right now beginning to populate its docket for the current term, the future term, even during this current term. It's got about 20 cases altogether right now on its docket. Recently added about 6 more. Let me tell you a little bit about those 6 cases, things we're going to be chatting about probably next year this time, the same kind of period, May, June, July, perhaps, as we think about what the Supreme Court's having on its docket. Just a few weeks after we observe the 80th anniversary of the D-Day landing, Supreme Court is going to be taking up again, as indicated, some issues related to international law. At the issue in a case called Republic of Hungary versus Simon is the interpretation of something called the Foreign Sovereign Immunities Act. The Foreign Sovereign Immunities Act, that's a law that generally prevents lawsuits against foreign governments in U.S. courts, but it carves out one exception. And that big exception is known as the expropriation exception. And that basically says when the lawsuit involves property that's taken in violation of international law, and secondarily, there's a commercial connection between that property and the United States. The plaintiffs in this particular case allege that the Hungarian government took their property, they sold it, that they put the proceeds from the sales of that in some general state government treasury, and later used those funds from the treasury in connection with the country's commercial activities here in the United States. They're plainly understanding what this exception, the expropriation exception, is all about. A federal appeals court in D.C. agreed that these allegations are enough to establish a statement of claim here, unless the Hungarian government can show otherwise. And a court in New York ruled that the plaintiffs needed to show a more strong connection between the funds and the expropriated property. All of that now in front of the Supreme Court in its next term. Case called Republic of Hungary versus Simon. There's another case, also fairly wonky, but equally important, if you will. United States versus Miller. It's a bankruptcy case. Agreeing to decide, the Supreme Court is, a complicated bankruptcy question that arose under a particular mechanism for filing bankruptcy way back in 2017. The question there, whether the justices will determine about the power, once again, of the bankruptcy court and indeed the bankruptcy trustee. That's an office of the U.S. Department of Justice, has some responsibilities for justice and presentation of matters before bankruptcy courts. Whether the bankruptcy trustee can reverse a debtor's payment plan, a tax payment plan in particular, to the United States when there's no actual creditor in the bankruptcy that could have obtained that relief. Fairly wonky, but important in terms of bankruptcy. We know just this past term that the court also took up this other bankruptcy case involving the Sacklers and Purdue Pharma, finding that the bankruptcy court did not have authority to enter into this omnibus bankruptcy plan that would have provided funding for recovery and also support for the victims and victim families of the opioid crisis. In a case written by Neil Gorsuch, an opinion written by him, the court saying no authority. We'll see in this other case, United States versus Miller. What is the authority of the bankruptcy court? What is the authority of the bankruptcy trustee in a situation where an actual creditor could not have obtained relief? Can the trustee do? There's another case called Feliciano versus Department of Transportation, involving in some ways the rights of civilians and also people involved and who are protecting our nation as our soldiers in the armed services. The justice agreed recently to weigh in on this question, whether a federal civilian employee, somebody in the civil service, who's called to active military duty during a national emergency, is qualified to receive what's called differential pay. Differential pay is the difference between compensation for your civilian pay and the military pay. If there's a difference between those, are you entitled to receive that differential pay even if the duty that you're called up to do is not directly connected to the specific national emergency? The question comes to the court in the case of Nick Feliciano. Nick Feliciano versus Department of Transportation, which of course is where he works. He's an air traffic controller. He was called to active duty in the Coast Guard, where he manned a vessel in and around the Charleston, South Carolina harbor. An interesting question about payment for our military
service soldiers and others, in this case, in the Coast Guard, called up to active duty. Another case called Stanley versus City of Sanford, California, a case involving the Americans with Disabilities Act. Supreme Court had one of those cases this past year, basically dismissed it because as it was moot, as the petitioner there did not pursue the claims. In this case, Stanley versus Sanford, Florida, justice is going to be considering a question arising under the ADA. Does a former employee lose her right to sue over discrimination in the provision providing benefits that she earned while she was employed? The question specifically comes up in this particular case called involving Karen Stanley. She worked as a firefighter for the city of Sanford, thus the plaintiff and the defendant, for more than 2 decades or so before Parkinson's disease forced her to retire. She filed a lawsuit under the ADA, and she's alleging that the city's benefits policy discriminated against her in receiving disability benefits as a retiree. Court of Appeals for the 11th Circuit ruled that she was not a qualified individual protected by the ADA because she was not currently employed by the city. That's the 11th Circuit saying she's not entitled to those benefits. The court now determining whether the Americans with Disabilities Act does in fact give Karen Stanley the capacity, the ability to get those benefits. Another case involving the environment, also much on the docket of the Supreme Court this past term, as it found that the Biden administration could not do this Clean Air Act package of things having to do with polluted airs drifting from one part of our country to another. Its so-called Good Neighbors Plan, finding that that is not supported by the law, not supported by established rules of the EPA. The court once again taking up another environmental case, this one called 7-County Infrastructure versus Eagle County. 7-County Infrastructure versus Eagle County. Whether the National Environmental Policy Act, called NEPA, requiring federal agencies to examine the environmental effects, as they always do, of proposed actions by the federal government and to inform the public, you and me, of the environmental issues that it considers when making its decisions. Does that law, NEPA, does it require the agency to study environmental impacts beyond the immediate effects of the action that the agency has authority to regulate? How far can they go in studying these environmental impacts? Question comes before the court and a challenge to the scope of that particular law. All of that coming up before the Supreme Court very soon as we consider more about what's on the docket of the United States Supreme Court here on Amicus, a law review.
This is Amicus, a law review. My name is Jim Santelle, talking again about the Supreme Court as we have for a long period of time here on the broadcast stations of Civic Media, commenting in particular about the fact that the Supreme Court is now populating its docket for the next term, that is the 2024-2025 term. It's going to be taking up probably about 60, maybe 70 cases altogether. Already has on that docket about 20 such cases, anticipating likely a similar number as it has done in the past. We talked about this international case, government seizures, this bankruptcy case pending before the Supreme Court in the next term as well. Military office benefits, the Americans with Disabilities Act, an environmental case, and also another case called Dewberry versus Group Engineers. Justice is determining whether a plaintiff in an intellectual property case, if that plaintiff gets an award of defendant's profits, in other words, they file a lawsuit against someone who's violating their trademark, their copyright, and under a thing called the Lanham Act. We've talked about that from time to time. That's one of the federal statutes establishing intellectual property in the federal system. For a trademark violation, can that award include an order for the defendant, the person who violated the particular trademark intellectual property right? Can the award include a requirement that the defendant turn over the profits that he, she, or it acquired by a separate corporate affiliate that's not a part of the case? not a part of the formal litigation. An interesting trademark case, as again, going forward, this case called Dewberry Group, Dewberry Enterprises, a trademark case, also joining the others before the Supreme Court as it continues to populate its docket in the coming months, as it begins then in early October, its next term, for the benefit of the American population as it continues to attempt to resolve these many issues, big and small, important for all of us to understand, obviously greater importance depending upon the nature of the specific challenge and the lawsuit that ultimately comes before the court. We value, as always, your comments and questions, 844-967-2789. And we especially appreciate Jack calling in from Merrimack this weekend. Your question or inquiry or comment. Jack, glad to have you with me.
Yeah, this is fairly long, so feel free to interrupt me if you think you need to. But I'm wondering what's going on here. Lower courts, and Cannon in particular, ignoring precedents and statutes. Lower courts that tell the FDA that a drug is unsafe, ignoring decades of evidence, studies that show the opposite. Supreme Court ignores the legislation that establishes regulatory agencies and their ability to regulate, and to use experts that are have objectively studied cases and use their evidence to regulate. Supreme Court so-called justices, having stated during their confirmation that precedents are established law, and then they ignore and reverse those precedents. Aren't those people under oath when they're under confirmation hearings? Isn't that perjury? So-called originalists, Federal Society Supreme Court justices, and they ignore the clear intent of the Founding Fathers in our Constitution that a president doesn't have royal rights to immunity for illegal acts. And they give him nearly blanket immunity for those acts. And even the president made a presentation of evidence for those illegal acts.
Right.
I thought even client-lawyer communications involving unlawful plans weren't subject to such confidentiality. And it's pretty clear from the Constitution the Supreme Court never intended to have this kind of power. They're not just making new interpretations. What some of them said was established law. They're changing the laws.
Right.
They're essentially stating that only they can do so. They're completely overstepping, in my opinion, the line between the separation of powers. And when Biden took office, I gave the opinion that he needed to do two important things at the top of his agenda. The first, given the egregious voter suppression and disenfranchisement that was going on, to pass the Voter Rights Act, but mainly this, since McConnell already stacked the court, to rebalance it by adding 4 more justices, which incidentally I think would be appropriate given there are 13 federal court districts. And let's not even get into the unapologetic and paid-for corruption of some of these justices.
And Jack,
what's happening here?
I think that you express the frustration not only of the dissenters in many of these cases you've identified along the way, this notion that we are not only drop-kicking precedent, but we're overturning fundamental notions that are in the Constitution, not just because they're long-standing and not just because they're written there, but because they advance justice, right? And that's the concern. That's, I think, what the president's concerned about. You've identified a number of these areas where I think Americans can legitimately say, what is going on here? And ask not just the rhetorical question that you've asked, but also, what do we do about it? You know, as we talked in recent broadcasts, we've got recommendations from at least a couple of the Supreme Court justices, especially in connection with the immunity case. This other one you made reference to, of course, that's the Loper Bright Enterprises, overturning the ways in which our administrative agencies work and their connection to the people and courts in particular. A recommendation from the dissenting justices that's now up to us. It's now up to the people, again, to articulate exactly what you've articulated, Jack, and to be out there and say, you know what, we need to do something differently here. I've commented in the past about how in Israel, as we have talked on this broadcast in the past, when they faced, long before the war right now blazing and going on in Gaza, between those forces there. Long before that, when Benjamin Netanyahu proposed a significant diminution in the power of the courts, the people of Israel got out into the streets and they said, you know what? this is not the rule of law for our nation. This is not what we want. And they shut the country down. They shut down the airports. They shut down the streets, the academic institutions, commercial businesses. They kept medical offices and hospitals open only for non-elective surgery. And so all of those kinds of things makes you wonder if America needs likewise to respond at least to these recent matters. You've identified virtually all of them in which the court is moving beyond fundamental notions of justice and also expressing, I think it's implicit, if not explicit, in what you just said, Jack, a real contempt, as I've talked before, about the basic institutions of our system of justice. The decision in the Trump case suggesting that grand juries and pretrial rulings and jury instructions, all the other trappings of what we anticipate in any criminal case are simply no longer good, at least not good enough for a president. All good points, Jack, and notion that we need to respond to this as people in the country who are concerned about this movement. The president concerned, obviously others in Congress, others on courts are also concerned. All of us need to be a part of the response to what you've identified. Appreciate so much the comment and the encouragement to do something more. We take Jack's good thought about the future of our nation, and we also talk about what happens in our courts when the justice system works properly, and when, in fact, things happen in the courts, our civil courts, our criminal courts. Admittedly, especially in the criminal setting, as I've commented in so many instances, all criminal prosecution is human tragedy. Commented about that a lot. We know that just this past week, that played out again, actually past month or so, when Senator Robert Menendez, New Jersey, powerful Democrat, prosecuted by the Department of Justice, formerly of the Robert Menendez, still on the Senate Foreign Relations Committee, question about whether or not he will continue in the United States Senate in the wake of his conviction for participating in a vast international bribery scheme, again, brought by the Department of Justice, not by special counsel, but by line attorneys in the criminal division, in the public corruption section. Prosecutors said he accepted gold and cash and other payoffs, hundreds of thousands of dollars in exchange for political favors, both abroad and at home. Abroad, that's the Egypt connection. A Manhattan jury returning just this past week, deliberating about 13 hours or so over 3 days in the federal court there, finding Robert Menendez guilty on 16 counts: bribery, honest services wire fraud, extortion, obstruction of justice, conspiracy, and yes, acting as an agent for Egypt. A jury. The process went forward. A judge presiding over that case named Sidney Stein, a jury determining in the end that there is indeed proof beyond a reasonable doubt that Senator Robert Menendez engaged in this conduct. He becomes the first U.S. senator ever to be found guilty of acting as an agent of a foreign power. Again, that foreign power is Egypt. 7th in our history to be convicted of a federal crime in office. It is tragic, not only for him, not only for the people of New Jersey, for all of us, but it also sends some messages in the way that the now convicted defendant responded to all of this. He has indeed, up to now, resisted calls to step down, and we'll see what he does in the future. That may, in fact, happen. He is pondering that right now, but it's important to take a look at what he said after this verdict. The things that he said that are appropriate in contrast to other things that another defendant has said in another setting that are inappropriate. Here's what Senator Menendez, just convicted of these offense conduct in the federal district court, said he was deeply, deeply disappointed by the jury's decision. Said that he has every faith that the law and the facts do not sustain the decision. He'd be successful on appeal. He said, "I've never violated my public oath. I've never been anything but a patriot in my country and for my country. I've never been a foreign agent." Now, all of that are things that we not only anticipate, but we permit and we embrace defendants saying, continuing to maintain, even though the jury has found to the opposite. And yes, indeed, the presumption of innocence no longer attends him. He is a convicted felon in the federal district court. Still, the nature of what he says, note what he doesn't say. He doesn't attack the judge.
that judge, again, Sidney Stein. He doesn't attack the jury for its deliberation. He doesn't call the process itself a sham, a witch hunt. He doesn't impugn the integrity of the prosecutor. The prosecutor is from the Department of Justice. He maintains his innocence. That's the kind of thing that we anticipate from defendants, even in the wake of a conviction. Does he have a right to appeal his judgment? Of course he does. And he's indicated he will do that. He will continue to maintain his innocence. That's the kind of thing that the First Amendment and the rights that are attended upon any defendant are all about in America. What Senator Menendez does not do, even in the wake of this horrific result for him, for New Jersey, for the Congress of the United States of America, and for all of us, what he doesn't do is he doesn't send messages to the United States of America and all of our citizens, 334 million of us, that the system is somehow broken and that this is a result of corrupt judges and bad jurors and tainted prosecutors and witnesses who lie and people who come into the court and do not, in fact, take their oath seriously. Significantly, two other businessmen, a fellow named Wal Hanna and Fred Dybes, also convicted, also part of the guilty counts in this jury verdict likewise. Not attacking the system, maintaining their innocence, but not undermining the very structures by which all of this happens. Still, even in their protests about the nature of the conviction, the sentence to be imposed upon them by Sidney Stein, October 29th, carrying potential sentences of up to 20 years in prison. Even in the midst of all of that, this human tragedy, not attacking what Donald Trump has done in that Manhattan courtroom along the way, not requiring the imposition of an order by the judge, by Judge Stein, that he not talk about these people, understanding, as even Robert Menendez does, who plainly should no longer be a public servant, no longer be in the United States Senate, should now face the results of what he has done to compromise the basic duties and responsibilities that are his and others under our federal criminal code and under the basic trappings of public service. He's got to face all of that. But even doing that, even in the midst of that tragedy, he also implicitly, if not explicitly, does precisely what Donald Trump did not do in saying, when Donald Trump did say repeatedly that all of this is the product of corruption. And so we take away that and other lessons from the Menendez conviction of conspiracy in this broad international charge against him. And then we also think about things overseas. And as we continue our discussion here on Amicus, a law review, we're going to talk more about things happening overseas and contrast those with what's happening in our courts here in the United States of America as Amicus, a law review, continues. This is Amicus, a law review. My name is Jim Santelle, talking about the ways in which courts administer justice here in our country and also in other places overseas. A couple of rule of law snapshots. We also know that there are courts both here in our nation and overseas that do embrace the concept of due process and notice and evidence and the predicates for ultimately delivering justice. We know just this past week that the United States Department of Justice has returned a major indictment against a former North Korean expert and someone who was with the Council on Foreign Relations and previously acted on behalf of many foreign policy entities, a woman named Sue Mi Terry, alleging, again, in a present indictment that she engaged in extensive activities for and at the direction of the South Korean government, did not register as a foreign agent. She faces 2 counts, one for failing to register as a foreign agent and the other for conspiring to violate. That comes out of a process in our system. She is still presumed innocent. A grand jury process that reviewed not only the specific facts here, understood the law as presented to it, and returned, again, not a finding of guilt, but a determination that the case should go to trial. That a part of our process. We also have another matter coming out of the International Court of Justice just late this past week. Again, a part of a process, not in our courts,
but in the International Court of Justice on Friday of this past week, saying that Israel's occupation of the West Bank and East Jerusalem, settlements there, violated international law, probably the most sweeping stance it's taken. The Israeli settlements, the court says, in West Bank and East Jerusalem, and the regime that was associated with them have established there and are being maintained in violation of international law. Now, all of that also the subject of contest and of disagreement and of argument, of evidence presented in both directions. We know that the Prime Minister, Benjamin Netanyahu, has dismissed that finding. And, of course, there are an awful lot of people who look at that on both sides, who embrace it and do, in fact, dismiss the finding. The point is, in both of these, both in our courts and also in the international court, there is a process that requires the presentation of evidence and judges making determinations, perhaps imperfectly, but also subject for review and appeals inside the Justice Department and also in the appellate views of the people generally. Contrast all of that to what we also saw this past week when a court in Russia, also on Friday, sentenced Evan Gershkovich, who's a reporter for the Wall Street Journal, to 16 years in a high-security penal colony, ending there the espionage case, but maybe opening up the possibility for his return there. The reason that this is so significant is because what happened along the way. Mr. Gershkovich, again, this reporter for the Wall Street Journal, denying any charge of espionage, reporting in Russia, says nonetheless that he did not do anything in violation of law. The parent company of the Wall Street Journal describes the conviction as unsupported by the law, disgraceful, does describe it as a sham, and notes that we'll continue to do whatever we can do to press for Evan's release and support his family. The significant point behind all this is that there you do have a process, a court that plainly is not embracing all the other trappings of a process here. The court said that the totality of the evidence presented was sufficient to render a guilty verdict, and the court imposed this 16-year sentence based upon evidence that's far, far from clear. The release of the indictment last month was the first time that the Russian state had even revealed any details about the case. No transparency at all of the sort that we would have, and did not provide, and still have not provided, any specific evidence to back up this charge of espionage. The proceedings on Friday, both sides were given the opportunity to deliver some final arguments, were behind closed doors. Unlike our courts, unlike the other courts around the world in nations that embrace the rule of law, this one behind closed doors, we don't know what the charges were with specificity. We don't know what the evidence was. Journalists, like the defendant here, Evan Gershkovich, not permitted to be a part of the proceedings to watch what's happening. They came to the court building in about 900 miles from Moscow, not allowed to see the defendant in the courtroom. And the case actually sped up. Of course, about 2 or 3 hearings in recent days. It was announced the second hearing, probably hours, if that, in length, have moved ahead very quickly in the course of all of this. Plainly not enough time to do what we would call a trial, where there's evidence that attorneys can weigh and sift, that a judge, a court, can weigh and sift. The first hearing in the Gershkovich case took place in June. On Thursday, in the second hearing, the court wrapped up its investigation and the evidence, hearing witness testimony, and it was done. Now, as a result of all of this, it is very clear that the court not only accelerated its movement on this, but also reached this verdict, as I indicated, without any clear exposition of evidence to support this particular espionage charge, without the kind of deliberative review that we anticipate and that we contemplate and that we have seen in the processes in other courts, in federal courts, state courts in our nation, and in others around the country. Now, the only good sign from all of that, the expedited and the summary nature of this, is it may be a predicate to the release of Mr. Gershkovich, if in fact the United States of America, through the State Department and others, through the president himself, decides to engage in a prisoner swap. And that could happen down the road.
And that may well justify the expedited nature of this, but still, in its constitution, this kind of court, completely unknown to our system of justice, there in Russia, that's the kind of thing that you get that is a sham court, that is a witch trial, if you will, a witch hunt, the kind of thing that Donald Trump ascribes to our courts unjustly, inappropriately. In Russia, you've got that, but not here in the United States of America. We note as well that a Moscow court has also sentenced recently a fellow named Michael Leak, an American rock musician, to 13 years in a high-security penal colony. And we also know that other Americans, including Paul Whelan, a Marine veteran, Alusu Kurmaseva, an editor working for Radio Free Europe, and Mark Fogel, a teacher in the Anglo-American school in Moscow, all of them have been detained in Russia on various charges. And they're also plainly the subject of consideration, not only about the ways in which justice is delivered there, but probably, certainly we know, behind the scenes attempts by our government to get their release in various ways, arguably involving swaps as well. We think about justice as we think today and this weekend and all times about the future of our courts, both international, here in the United States of America. We invite your continued participation down the road as we continue to talk about the rule of law and government and justice here on Amicus, a law review. Thank you for joining me, everybody.